Travelers having their cell phones, computers, and other electronic devices searched at the border or the international airports. This is something we hear all the time these days on the news. But in reality, this is nothing new. The government has long relied on what's called a border exception in conducting these searches. But the question is, how far can they dig? How much information can they get out of your cell phone? And how can you protect yourself and invoke the Fourth Amendment? Now, if you've been following this channel, I have discussed many cases regarding the border exception. And today, let's focus on the Ninth Circuit case United States versus Cano, which deals with a search of a phone. First, where the officer just simply looks through the phone, and then they actually do a forensic analysis of the phone. And the question is, can they do that under the Fourth Amendment? Well, before we go on, I want to thank you for watching me here on YouTube. If you're new here to the LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible, Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstache.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
As you already know, today we're discussing United States versus Cano, a case from the Ninth Circuit that was published in 2019. It deals with the border and a cell phone search. I am intimately familiar with this case because, of course, it comes from my district, the Southern District of California, where I practice here in San Diego. So if you have a case similar to this one, feel free to give me a call. This is my bread and butter. Of course, I handle many of these cases every day because I'm at the border, and of course because I'm also on the federal panel here with the district court. So if you have a case similar to this one, give me a call. Let's talk about Mr. Cano. Mr. Cano was living in Los Angeles, and at some point he moved to Tijuana and began living there with his cousin. Now, many people in San Diego and Los Angeles, here in the Southern District of California, often move to Tijuana because it's cheaper, so there's nothing suspicious about that. Many people do that. Well, Mr. Cano begins living in Tijuana, and he crosses into the United States only 6 times before being arrested. Now, during those 6 times, a few of them were very brief visits to the United States. In fact, he was here in the US only for 30 minutes before crossing back into Tijuana. So on the 7th time, the Border Patrol agents and the Customs agents were seeing that this was somewhat suspicious. So they ran a canine around the car, which alerted to narcotics, and because there was already a flag on this car, they sent it to the secondary. There the officers discovered about 14 kilograms of cocaine. Of course, Mr. Cano gets arrested, he gets interrogated, he waives his Miranda rights, so he allows the officers to question him without a lawyer, which, by the way, you should never do. And so during this interrogation, they ask him what were the reasons behind him traveling to the United States. And he explains that he was trying to find work, namely carpeting store work. He was doing installation of carpets. Now, during the interrogation, the officers first conducted what's called a manual search of the phone. They simply opened it up and looked through the call log. And they then noticed that the call log was very lengthy. However, there were almost no text messages. Mr. Cano explained that his family suggested to him to delete all the text messages because of the police in Mexico. He thought that if he ever gets pulled over there, it's better not to have anything on his cell phone other than people he calls, only a call log, and no text messages. Again, the interrogation went on, and then there was a second time when the officers did a manual search. This time the officer also wrote down some of the phone numbers on a piece of paper, I assume to have a follow-up investigation. And then the third time, the officers then took the cell phone and did a forensic analysis. They downloaded all of the information using a Cellbrite software. This is the software that we use all the time here in the Southern District of California. Essentially, it allows the officers to download all the information off of the cell phone, including photos, a call log, any of the information about your travels, like geo information, for example, where you took the photos, and by the way, including all the photos. All the information gets downloaded neatly into a software application. And so now we have basically three types of searches of this cell phone. The two manual ones, and now using this software. Mr. Cano argues that the officers were not permitted to search his cell phone without a warrant. So first, let's talk about the Fourth Amendment. The Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Ordinarily, before conducting a search, police must obtain a warrant issued by a judicial officer based upon probable cause supported by oath or affirmation, and particularly describing the places to be searched and the persons or things to be seized. Warrants are generally required unless the exigency of the situation make the needs of law enforcement so compelling that the warrantless search is objectively reasonable under the Fourth Amendment. Now let's quickly run through all the case law as it relates to the border, cell phone searches, and the Fourth Amendment in generally. Let's begin with Riley versus California, which said that your phone is not immune to searches. However, officers generally need to have a warrant before looking into your cell phone. But here's the thing, Riley versus California was a case involving an exception called incident to a lawful arrest, where the individual is arrested and the phone is being seized. The officers then have to generally get a warrant before looking at that cell phone. The next case let's talk about is United States versus Hernandez de Montoya. This is the case that told us that there's two types of searches at the border. There are routine searches, where the officers don't need to have any sort of suspicion whatsoever to conduct, such as where you go through the metal detectors at the airport. And then there are non-routine, more invasive searches, where the officers have to have reasonable suspicion and particularized suspicion before conducting a search. For example, a cavity search at the airport or the border. And finally, we have United States versus Cotterman. This is the case about electronic devices, namely cell phones and computers, at the border. And the Ninth Circuit said that officers of Customs and Border Protection must have reasonable suspicion before conducting a forensic search of the phone or computer at the border. So this case, United States versus Cano, now marries all of these cases together into one neat package. Applying United States versus Cotterman, the panel held that manual cell phone searches may be conducted by the border officials without reasonable suspicion, but that forensic cell phone searches require reasonable suspicion. The panel clarified Cotterman by holding that reasonable suspicion in the context means that officials must reasonably suspect that the cell phone contains digital contraband. The panel further concluded that cell phone searches at the border, whether manual or forensic, must be limited in scope to whether the phone contains digital contraband, and that a broader search for evidence of a crime cannot be justified by the purposes of the border search exception to the Fourth Amendment warrant requirement. Putting this in simpler terms, okay, the officers can manually look at your phone at the border or the international airport, meaning open up your phone, look through the call log, pictures and whatever else manually by hand. But they need to have reasonable suspicion that contraband would be on the phone before conducting what's called a forensic search, downloading all of the information with software, for example, Cellbrite. And once we know the type of search that the officers are conducting, the next question is scope. And here in Mr. Cano's situation, the court said the original first and maybe even the second search where the officers manually look through his phone is okay. Again, no reasonable suspicion is even required in that situation. But once we're looking forensically at the phone, where the officers download everything, one, we need to have reasonable suspicion, and two, the scope of the search must focus on contraband. Now, contraband is different than evidence of past or future crimes. What do we talk about when we're discussing contraband? For example, certain type of pornography is illegal for you to have on your phone. And so if the officers see that on your phone, that is contraband. That is direct evidence of the crime itself. But a call log, people you call, is not necessarily contraband. In fact, there's nothing illegal about a list of phone numbers that you've called previously. And so here, the Ninth Circuit says, in Mr. Cano's situation, the officers were no longer looking for contraband. They were looking at evidence of prior crimes. Has he crossed before with narcotics? Who he called? And the court says, in this situation, the officers had time to obtain a warrant, which is something they should have done. So if we're talking about forensic searches, usually the government will try to obtain a warrant. And if they don't, talk to your lawyer, because that evidence should be suppressed and cannot be used against you. Like in Mr. Cano's situation, most of the information that was found on his phone could not be used against him at trial. So now that you understand about this case and how the border searches as they pertain to electronics work, let's answer a few questions. Okay, question number one. Do I have the same legal rights at the border that I would elsewhere in the United States? The quick answer is no. You just learned about the border exception, meaning that at the border, and when we're talking about the border, we include, of course, the ports of entry and the international airports that you might arrive from another country. There, you do not have all the rights that you might have under the Fourth Amendment. That is because the government's interest in protecting the country trumps your rights under the Fourth Amendment in most situations. Well, you've learned about the border exception as it relates to cell phones. You know about routine searches versus non-routine searches. And so you know that if you're going through a metal detector that is a routine search, the officers do not need to have any sort of reasonable suspicion. If you want to enter, you have to put your bag through the X-ray machine. We know that. But of course, cavity searches must have reasonable suspicion before conducting that. Question number two. Didn't the Supreme Court rule that the police must get a warrant before searching someone's cell phone? Well, yes. This is, of course, Riley versus California. This is the case that dealt with search incident to arrest, where the Supreme Court said that, yes, officers generally need to have a warrant before conducting a search of a cell phone. But remember, we're dealing with a border, where the border exception is different than search incident to a lawful arrest. Question number three. So, could my laptop, phone, or other electronic device be searched as I return from traveling abroad? And the answer is yes, it can be searched. From this case, United States versus Cano, Cotterman, and others, you've learned about the searches of electronic devices. You know that if the officers are doing what's called a manual search, they don't need to have any sort of reasonable suspicion whatsoever. But if they're conducting a forensic search, they will need to have reasonable suspicion that contraband will be found on the phone. And again, you know the difference between contraband versus evidence of prior or future crimes. Those are different. So always focus also on the scope of the search, which is what are the officers looking for when they're looking at the phone. And remember, the Fourth Amendment protects against unreasonable searches and seizures, and we know that it doesn't matter that you're a citizen of the United States. The border exception will still apply to you. Your legal status in the United States does not matter. What about the data on my phone, computer, or other electronic devices? So again, officers can conduct what's called a forensic search, where they download everything off of your phone. So here's a tip. If you're traveling internationally, consider getting a second cell phone, or at the very least, limit the information that's on your phone. Don't have extra files, extra photos that you don't want the government to see. So limit the information that the government will be able to obtain after they conduct a forensic search. I know there was a little pause after the last question. That is because I looked through the rest of the questions and then I realized this video is already running long. Enough is enough. You've heard enough of the border exception as it relates to all the cell phones and other electronic devices. If you have a case here in the Southern District of California where you've crossed through the border and were arrested, consider giving me a call. These are the cases I handle every day in the Southern District of California. Of course, I'm also licensed in Nevada, and I take cases throughout California generally, even up in Northern California as well. Well, thanks so much for watching me here on YouTube. If you're new to the LAWSTACHE channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to be a superstar, well, go to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching, and I'll see you next Wednesday for another deep dive on another case. Thanks for watching.